of the sentence. Again, very briefly. The prosecution submissions are dated 6th of March 2024. Before those submissions, the court had sought for the records of the accused person. The court received the records, and the accused person is indeed a first offender. That fact has been considered in this decision. My understanding of the submissions by the prosecution are that they have invited this court to look at the aggravating factors in this matter, and they have outlined them as follows, and I'll read them out. The prosecution invites this court to note that on 20th day of September 2018, the deceased Monica Nyawira Kimani lifeless body was found inside a bathtub with her throat brutally slit and hands tied. The court is invited to note that the post-mortem report produced by Dr. Peter Ndegwa confirmed that the deceased Monica Nyawira Kimani died due to severe neck injuries due to a sharp force. The court is being invited to consider that there was serious and grievous harm occasioned to the deceased. The court has been invited to consider that the weapon used was a dangerous weapon, and that the offense was an intricate planning. There was intricate planning of the offense. And in capital letters, the court has been invited to note that there was no degree of provocation from the deceased person towards the offender. And finally, the court has been invited to note that after commission of the offense, there was an attempt to conceal the evidence. Not finally, there is one more. The court has been invited to consider that the crime had serious physiological and physical harm to the victim and the family. Based on these factors, the prosecution argues that this court should mete out the sentence as provided for under the law. They have invited this court to note that despite the decision in the case of Muratetu, the only thing that that case did was to declare, and I will put it clearly, that the mandatory, and I will repeat, the mandatory nature of the death sentence is unconstitutional, and that it did not declare the death sentence unconstitutional. And so, without going into other areas of submissions which are reflected in my judgment hearing, the prosecution invited this court to pronounce a death sentence. The victim's family, in their submissions dated 7th of March, drew the court's attention to the sentence provided for the offense of murder, which sentence is stipulated under section 204, which says that a person convicted of the offense of murder shall suffer death. They led the court through the objectives of sentence, which I've spoken to, and therefore I'll not repeat. And they invited the court to take cognizance of the fact that the accused person before the court did not play a peripheral role in the commission of the offense, but he was the main perpetrator of the offense. In that, they are saying that he did not only steal an ID card of a third party, but used it to disguise his identity, changed his clothes and went to the deceased's house and brutally murdered her. They described the murder as being cold-blooded, ghastly, and barbaric. They have invited this court to consider that no amount of monetary compensation can ever bring the deceased back. And they have invited this court to note that the death of the deceased occasioned the family a lot of economic loss, as the business of the family that she was manning in South Sudan collapsed, and that it was the only means of income for the family. Finally, the accused person filed their submissions in form of mitigation dated 10th of March. And I think it's important I take a bit of time in our understanding of what the accused person said, because he is the one on trial. So I will not summarize too much his mitigation, and also for the parties to appreciate that I've taken it into consideration in totality. The accused says that he's aware that nothing he says at this stage will relieve the pain of the deceased family. And he says the lesser he says, the better. He says that he expresses his sadness that such a tragic loss of life on extreme circumstances bordering, and this caught my attention, okay? He says that he expresses his sadness that such a tragic and careless loss of life on extremely circumstances bordering on an act of absolute madness that is beyond understanding, even to him, as he stands there convicted. He says that it is his prayer that the deceased family will find peace and that her soul will rest in eternal peace. He says that he understands the terrible fear and pain that the deceased must have underwent in the hands of the perpetrator, and he cannot even perceive the same. He joins the victim's family by saying that he does appreciate that monetary compensation cannot relieve the pain of the loss of a loved one. The court has been invited by the accused person to note that by the Supreme Court declaring the mandatory nature of death sentence to be unconstitutional, then it opened room and gave this court the discretion to mete out a sentence that is not necessarily death. And the accused then says that in that case, and again, this was very important to the court and for reading, because I come back to it. He says that in that case, it is his prayer that the court can mete out a custodial sentence. He says that although the victim's family in their submissions are calling for a death sentence, but the father of the victim, Bishop Paul Garama, was publicly heard saying that he will not take vengeance. And so, the court should consider his views. Finally, the accused person invited the court to consider that he is a first offender that he was convicted purely on circumstantial evidence, and the period he has spent in custody. That, in my considered opinion, was the additional evidence given to this court in form of submissions by the parties at the close of the formal trial. In looking at the goals of punishment and in considering the objectives, I made reference to inclusivity. And I said that before a sentence is meted out, the views of the victim and the community are extremely important. And so at this stage, I want to speak to the pre-sentence report that this court was given. Now, I must thank the probation department because they gave me an extremely detailed pre-sentence report. What comes out of that report is this: that the accused person before this court is 33 years old. His parents are alive. He has 3 siblings who, from the report, are also alive. It speaks to their permanent place of abode at Guta Estate, which is just adjacent to NET, military barracks within Nakuru County. It indicates that this accused person completed his secondary school education in the year 2010. He then joined the Kenya Polytechnic and completed his training in the year 2011, where he qualified by being conferred with a diploma in food production. The report says that thereafter, and again this was critical for this court, he moved to Dubai, where he received training in tactical military at Dubai Police Academy and by a group known as Ogara Group, which he says that Ogara Group is a security firm with presence in Dubai, United Kingdom, and several European countries. And eventually, after that training, he was licensed to offer private security. The report indicates that at the time he was arrested, he was providing security in Kenya mostly to persons in political sector, and he was at an advanced stage of registering his own security firm. Outside his training and daily work, the report indicates that he's a staunch Christian in a relationship with one Jacqueline Maribe, who was his co-accused, and they were planning to formalize their relationship. At the time of the offense, they were both residing at Royal Park Estate in Langata, and they had resided together for over 1 year. Medical condition, the report indicates that he suffers from asthma since childhood, and that is usually triggered by colds and dust, but is on medication. It is indicated that he has developed nerve problems, and that arose out of a gun incident which we spoke to in the judgment and in this matter. But it's said that the same is treated by painkillers, which gives him relief. On the offense, the report says that the accused person maintains his innocence and that he was shocked and depressed to be linked with the murder of the deceased. That he denies knowing the deceased, but acknowledges that he knows his brother. And it says that he grieves for the family of the deceased for losing her in a gruesome manner. The report indicates that he has good relationship with his family. The sister stood by him throughout the trial. They describe him, that is his family, and again this is important, as a social, overly generous, respectful to authority, committed Christian, and he believes in innocence, although he believes in his innocence, although he has painfully accepted the conviction. The family of the accused says that they have been stigmatized, faced a lot of stigmatization and financial drain in form of legal costs. That they are expressing empathy for the family of the deceased and pray that the perpetrators will be found. And finally, they pray for leniency in sentence. From the community point of view, the probation officer interviewed a senior chief of free area location, Dr. Samuel Macharia, who described the accused person as being well-mannered, respectful, and was not a threat to the community. That the community is shocked by the charge that was preferred against him and subsequent conviction. That they vote for his good character, social standing, as they have known him to be a respectable youth committed to church activities. Bishop Shadrach Olo of Agape Sanctuary Church says that the accused person is a member of his church. He is steadfast in faith, relates well with fellow Christians, and at the time of his arrest he was a choir master in the church. He pleaded for leniency. The investigating officer, Mr. Maxwell Otieno, is indicated in the report as having described the accused person as an extremely dangerous person, violent in nature, as demonstrated by the fact that he was involved in an assault case with one Rogers at Club 1824 when he was out on bond in this matter. And that the reason why the case did not go forward is because the complainant withdrew the complaint. And the investigating officer called for the maximum sentence provided for under the law. The community from where the victim hails from in Thika described the victim as a person who had a promising future. They were shocked at her death and they called for a stringent sentence. The family of the victim. The family of the victim are reported in the pre-sentence report to have stated that following the demise of the victim, the death occasioned them monumental psychological impact, and they are still to cope with the said offense and death. And other than the father of the deceased who has received psychological counseling, none of the other family members have had the benefit of the same. It is indicated that at the time the probation officer was interviewing the mother of the victim, she broke down severally and wailed, forcing him to stop the interview to allow her to calm down. She is said to have indicated that she does not understand what would cause anyone to brutally murder her only daughter, who was her confidant and a very close friend. It is reported that following the death of the victim and the deceased, she suffered prolonged depression and consequently suffered stroke. According to her, the only appropriate sentence is death. the father of the deceased is reported to have indicated that the extensive media coverage impeded their emotional healing. The younger brother of the victim is reported to have ceased watching news, stopped trusting people, limits his movement, avoids going to public places, and only does online jobs. It is reported following the death of the deceased, as already indicated in the submissions of the victim, having been the managing director of the family business in South Sudan, the business collapsed. The family became drained financially, and they were not able to meet their day-to-day needs, as that was the main source of their income. In a nutshell, the family of the deceased hold the view that the maximum sentence provided for under the law should be pronounced, and they acknowledge that whatever the case is, even that particular sentence will not console them or erase their pain. Finally, the probation officer, and again this is very important and the court took note of the same. The probation officer, Mr. Andrew Kanyotu, in conclusion and his own observation, states as follows. He describes the accused criminogenic risk factors as follows. That he lacks stable partner relationships. He has antisocial personality patterns manifested by living on the edge. He is impulsive and a thrill seeker. He uses